morning. I am Judge Peterson, Justice of the Peace for McLennan County, Precinct 1. We're here today on an eviction suit. I now call cause number J12V25-0043. The plaintiff in this suit is Patricia Christian Conowall. Good morning, Ms. Conowall.
Morning.
And the defendant in this suit is Terrence Anthony Nathan. Mr. Nathan is with us as well. All right, you have both waived your right to a jury trial by not requesting one, which brings us to a bench trial or trial by a judge. That's what we're doing here today. Neither side is represented by an attorney. However, this is the People's Court of McLennan County, and in the People's Court, you're not required to have an attorney. In this court, you can have your voice heard and have judgment rendered following proper procedure. So the first order of business is to swear in the witnesses. You two are the witnesses. I'm going to ask you to simply raise your right hand so I can administer the oath to you. Do you, both of you, solemnly swear or affirm the testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes.
All right, thank you. All right, I'd like to now go to the petition that brings us to court today. And before I do that, I'll take judicial notice that it appears that the plaintiff has provided some documents to the court. I have the 3-day notice and some other things that you're going to have to explain to me. But we do have those ready for view if you need them. This petition, and Mr. Nathan, you have a copy of this petition that was attached to the paperwork that told you to be here today. So if you want to follow along, you can do so. This petition was filed in this court on January the 10th, 2025. Plaintiff is Patricia Christian Conowall, and the defendant is Terrence Anthony Nathan. The property is located at 192 Apartment D, Ambrose Street, Waco, Texas, 76712, which is in JP Precinct 1 of McLennan County. Now, the grounds for this eviction, it says for a lease violation. Do we have a lease in this eviction?
No.
Just a second.
Oh, sorry.
No, I'm asking you, ma'am. You filed the case.
Correct. I just want to also, the address is 1920.
1920.
Yes.
And it does say that on, it looked like a D. I apologize.
That's okay. Sorry. I just wanted to make sure.
1920 Ambrosia Street. Okay.
Correct.
Now, getting back to the grounds for the eviction, so there's no lease, so it can't be a lease violation. You're just wanting possession of your property?
Correct. I wasn't sure how else to file that other than lease.
The next one down says holdover. And when you ask someone to leave and they fail to leave, they become a holdover. So if we were here in person, if we were all together, I would give you the opportunity to amend your petition.
Okay.
However, since we're electronically, with your permission, if you wish me to, I can amend your position to reflect holdover.
Yes, sir. Thank you.
Okay. And you delivered your notice to vacate on the 9th of January, 2025. Is that correct?
Yes.
Okay. So I will put that date on the holdover. All right. Now, next thing the court looks at is the notice to vacate, and the notice to vacate shows to have been delivered on January the 6th, 2025, and shows to have been hand delivered personally to Mr. Nathan, which is proper. All right, so it looks like we're just talking about, well, I'll tell you what, why don't you go ahead and present your case and what do you want to achieve, okay? The snow wall, yes.
Okay. Um, so I'm just trying to kind of evict him slash remove him from the property. I own the house, and I've paid my mortgage this whole time solely. We previously were in a relationship. We've since broken up. We've tried a few times to come to agreement about him leaving and the dates that we have agreed upon. He's kind of just has not moved on since then, and we haven't been able to come to agreement moving forward with him leaving the property without it being enforced.
Okay. So it's basically your home,
Yes,
and you've asked him to leave. He didn't leave. You gave him a notice to vacate, and he still hasn't left. So now we're here in court today.
correct.
Okay. Fair enough. Anything else?
Not that I can think of.
Okay, Mr. Nathan, do you have anything to ask the plaintiff?
So ask her.
Okay. Do you have anything to say in your defense? That would be your time. I mean, it's pretty basic. She owns the property. She has the right to have whoever she wants there, but she also has the right to have you leave as well. Do you have anything to give in your defense?
All I can basically say is that has she asked me to leave before? Yes, she has. But to just say that I just completely disregarded leaving is not 100% true.
Did you receive this notice to vacate on the 6th?
She sent me a picture of it and placed it on my bathroom sink, but it was never placed in my hands.
Okay. Did you have it?
I saw it sitting on it's still sitting on my bathroom sink where she placed it.
Okay. But she delivered it to you.
I wouldn't say that she delivered it to me. She sent the picture of it to me, and then she came home and she put it on my bathroom sink. We live here together.
Okay. And you have a copy of it?
Yes, sir. A copy of one from the 6th and also a copy of one from the 7th.
Well, I'm looking from the 6th. That's the date that we're looking at here.
Yes, sir. It's still in the bathroom.
Okay. But you were aware of it?
Yes, sir.
Okay.
And then also, even since that specific notice was given to me, we've had several conversations where it was stated that we didn't have to go to court if we could pick a different date or we could just set a date. And then things just, I won't say things just kind of, we had a conversation. I thought that we would sit down and figure out a date to go about it in a copacetic way, but things just go back and forth a lot. And as far as like switching back and forth, you need to go, okay, you can stay. I don't think you should leave. You need to go, okay, maybe you shouldn't leave just yet. But besides all of that, honestly, I don't have an issue with leaving at this point. I talked to my son last night, and I just feel like it'll be best that I do leave and go back home to Louisiana, and I'm okay with that.
Okay. Well, by filing this suit, she's pretty adamant that she wants you to leave. Okay. And it's come to this suit, so we're here today. All right. Do you have anything else to add, Mr. Nathan?
I'm not sure. I don't even think that the actual reasoning behind the suit, that's the actual reasoning, will actually even matter in this hearing. So I'm not even 1,000% sure if I should even divulge the information or not.
No. Well, it basically comes down to ownership, Mr. Nathan.
Yes, so that's what I'm
She
saying.
owns the home. She has the right to have whoever there that she wants to be there, but she also has the right to ask you to leave. And she has asked you to leave. She's given you the information that she wanted you to leave. That's the process of this suit. The first thing is let you know you're still there. We're here today, and now we're going to put an end to this part of it. But
Yes, sir.
anyway, I think it's pretty sure that she wants you to vacate the premises.
I
Okay.
do.
I mean, just last week she said that we could figure something out to
Okay.
where I
Well,
could.
she brought this case to the court. The court is going to pass judgment on this case, and then we'll be through with it. Okay.
Okay.
All right. Do you have anything else?
Well, no, I was trying to explain what happened last week, but
But
I,
that's immaterial. The immaterial thing is you have notice to leave. You failed to leave. That's all that is in consideration of the court at this time.
okay, well, then I guess then I have nothing else to say.
Okay. Thank you. Ma'am, do you have anything else to add at this time?
Not necessarily. I do want to move forward with the eviction, just to make that
Okay.
clear.
We're about to do that.
Thank you.
All right. So having heard the evidence, the court finds for the plaintiff for possession of the property, and there's no back rent, so it would be possession of the property only. However, the court will award the plaintiff the court cost. That's the amount of money she had to pay to bring this case to trial in the amount of $144. Mr. Nathan, this is the judgment of the court. You always retain a right to an appeal. If you think an appeal is necessary, that's entirely up to you. However, if you do wish to appeal, it must be done by February the 4th. That's Tuesday, February the 4th. And to effect an appeal, you'll have to pay $1,000 into the registry of the court, and then it'll go to the next court, which is county court upstairs. But that's the judgment of this court, and you do have till the 4th to effect an appeal. That's entirely up to you. But otherwise, it seems pretty permanent that she does want you to leave and vacate at this time. Okay?
Yes, sir.
All right. Thank you both very much, and we are adjourned.
Thank you.
Good luck to you, Mr. Nathan.
I do have a question.
Yes.
So I know like usually there's a period of time that's required after if you don't even if you don't appeal that you have to be out by, like what is the time period for that?
Mr. Nathan, let me explain this to you. The judgment is that she gets possession of her home. You are to vacate immediately. The only way the only way you can avoid that is to file an appeal. You have until the 4th of February to file that appeal. If you don't file the appeal, you must move out. And on the 5th day of February, then the plaintiff can proceed with the next step of an eviction, which is a writ of possession. That's another legal term, but they'll issue you a notice. They'll give you 24 hours to vacate. If you don't vacate in the 24 hours, that's when the constable will come to the home on a date and time agreeable to the plaintiff. They'll come to the home and make sure that you vacate the property. That's the way it works.
Okay.
You want to let it go that far, that's your choice, but those are your options.
No, the only reason I was asking is because like just right now my situation is not conducive. I don't have a working vehicle, and I don't really have a way to go anywhere as of right now.
Mr. Nathan, I'm sorry for the inconvenience, but you've been given notice. You refuse to leave, and that she's at the point now where the court will force you to leave. Okay?
I did not refuse to leave, but okay.
Okay. Well, are you still there?
I've been allowed to be here as well.
Are you still in the residence?
Yes, we live here together with our son, and I've been allowed to be here.
Okay. This is an eviction, sir. I don't know what else I can explain to you. You might want to get an attorney to help you understand that, but you have been evicted from the residence. Okay?
I appreciate you.
All right. Good luck to you. We are adjourned. Thank you.
Thank you.